Here we are. And we have the group chat available as well. So if you have any questions during the presentation, go ahead and use the chat feature. That'll come directly to me. And it is, you can either chat to everyone or chat privately to me or chat privately to Jody during the webinar. And we will do our best to answer your questions. I'll stop twice during the presentation to answer questions about the two different topics or two different types of trust that we'll be covering. All right. And then I will turn it over to Jody, who will introduce me.
Welcome, everybody. So I'm going to introduce Samantha. Samantha Smith is an associate attorney at NM Law and a native of Orange County. Samantha has been with the firm for about 4 years and has been practicing law for about 6. Samantha's practice primarily focuses on trust litigation and administration, probate proceedings, and estate planning. Today, Samantha is presenting on ways to mitigate the risks of COVID-19 for elderly persons and those with disabilities through the use of an irrevocable trust, which is a tool long used by the wealthy to leverage state and federal allowances while protecting assets. This pandemic has created additional risk factors for the elderly and people living with disabilities that extend beyond contracting COVID-19. These include potential loss of medical insurance, inability to qualify for Medicaid, out-of-pocket medical expenses, and in the event of death, funeral costs. And with that, I will turn it over to Samantha.
Thank you, Jody. And welcome, everyone. Thanks for joining us. As Jody mentioned, I'll be presenting on irrevocable trust planning and specifically for people, elderly people and those with disabilities. And so this is our address, or actually it's not our address, but I'm at NM Law. As some of you know, that's our phone number and that's how I can be reached. I wanted to quickly introduce our team for those of you who may not know, everyone in the picture at least. So Noelle Minto is in the center. She is the founder of the firm. Ms. Minto has been a business and estates transactional attorney since 2003. Her practice is unique in that she endeavors to bridge the gap between trust planning and administration on the one hand, and business planning and management on the other. Ms. Minto is exceptionally talented at advising clients during dissolutions of marriage. She serves as on-call in-house counsel for companies in drafting and negotiating buy-sell agreements, employment and service agreements, and employee stock option plans. John Schrader is to her right. John is our senior litigation counsel at our firm who exclusively concentrates his practice in the areas of trust and probate litigation, conservatorship, and elder abuse litigation. John has an extensive jury and non-jury trial background, including will and trust contests, business litigation, real property, and insurance disputes. Mr. Schrader has been trying cases for over 35 years, obtaining verdicts and settlements into the 8-figure range. To John's right in this picture is Kelly, our litigation paralegal. Kelly has been a paralegal for over 8 years and has been with our firm for about 2 years. Kelly works with John and I on all of our litigation cases and probate matters. To my left in the picture is Monique Sanchez, our legal assistant. If you are a past or current client of our firm, you know Monique is always wonderful and easy to work with. Monique works on all of our business transactional matters with Ms. Minto. And we welcomed a second paralegal to our team last month who has not yet had her headshot done, but her name is Kate Ensley. And if you're working with Noelle on any estate planning matters, you'll be likely working with Kate Ensley on those matters. And today I wanted to present on the irrevocable trust planning. And specifically, I wanted to start with what is a trust for those of you who may not understand or know what a trust is yet. So a trust is simply just a contract or a legal agreement between a person and one person who owns an asset called a grantor or trustor. And then that same person, or it can be a different person, is called a trustee. This is the person who will be holding legal title to the asset for the benefit of the beneficiaries. The contract, the trust document itself, specifies how the assets are to be managed, administered, and eventually distributed to the beneficiaries. Trusts can be both revocable or irrevocable. Today I'm going to be presenting on two different types of irrevocable trusts, but wanted to go into the difference of what a revocable versus irrevocable trust is. So a revocable trust can be changed and amended at any time, as long as the person who created the trust has capacity. As soon as the person who created the trust passes away, typically the revocable trust is going to become irrevocable, meaning it can't be changed or amended any longer. The revocable trust is a pass-through entity, so it doesn't have its own taxpayer ID number. It has typically the grantor's taxpayer ID number or social security number, and the person who creates the revocable trust is going to be reporting all the income and tax information pertaining to the trust assets on their own personal tax return. Because the revocable trust is a pass-through entity, there's going to be little to no asset protection. That means that if you have creditors out there, or if you have a judgment or lien where your creditors are trying to attach to your assets, transferring title of those assets to a revocable trust is not going to protect you from those creditors. This is very different from the irrevocable trust, which is a completely separate legal entity and gets its own taxpayer identification number. Because it's a separate legal, it looks like we have one more person here. So because the irrevocable trust gets its own taxpayer identification number, it will provide asset and wealth protection, meaning that if you have creditors who want to attach a judgment or a lien against any of your assets, if you transfer them to an irrevocable trust, they're no longer your asset anymore. So again, the irrevocable trust just gets its own taxpayer identification number. On an annual basis, the person who is, the trustee of the irrevocable trust will be responsible for filing separate tax returns for the trust assets individually. And the one thing about the irrevocable trust that's very different from the revocable trust is that it cannot be changed or amended absent a court order. So the first type of irrevocable trust I wanted to cover today is called a funeral trust, also known as a funeral expense trust. These trusts are valuable for people who are getting older, close to the age of 64, and who want to be able to qualify for Medicaid health insurance at some point in the near future. So in the funeral expense trust, money is set aside or transferred into this trust, and then it is to be used to pay for funeral and burial expenses that a person or their family members will eventually have to pay in the future. So it allows a person to lower their countable assets by about $15,000 per spouse in order to qualify for Medicaid without violating the spend down rules and the look back period. So I'll go into what the spend down rules are or limitations are and what the look back period is here in California. But the big takeaway from this slide is that you can, it's $15,000 per spouse. And this is not including your principal residence. This is mostly just cash and other personal property. So to qualify for Medicaid in 2020, I've put the requirements in on this slide. First, you have to be over the age of 64 years old, and you have to have a financial hardship. So financial hardship is defined here, one person, the household income, and then asset limit. They're two different sort of measures that the Medicaid office is going to look at for every applicant who applies. So for household income, one person can have about $16,000 per year, translates into a little over $1,300 per month of income. If you have three persons living in one household, you can have up to $27,821 per year, which translates into about $2,300 per month of income. Now, asset limit is basically your stuff, right? Your personal property, excluding your home and excluding a vehicle and a couple other things that are under exempt property on this slide. But your asset limit is going to be cash in the bank. So you can see the asset limit is very low for one person, and even for a married couple, your asset limit is going to be $3,000. So if you have more than $3,000 in the bank and you are applying for Medicaid, you're unfortunately going to be denied unless you utilize the funeral expense trust. So the principal residence is exempt. This is huge, a very great benefit to have, because most people in the state of California, their biggest asset is their home. So the entire home and its value is completely exempt from being being calculated into the Medicaid qualifications. So if you own a home with $2 million and you only have $2,000 in the bank, you can still qualify for Medicaid in 2020. Other exempt property, I briefly mentioned one vehicle, household items, personal items with net value under $100, IRAs and other work-related pension plans, and then the life insurance policy with a face value of only $1,500 or less. So there's not a lot of other exempt property that the Medicaid office is not going to calculate in determining whether this applicant qualifies to receive Medicaid. But these are assets that can actually stay out of the burial trust. So it's just cash typically is going to be held in the burial trust to pay for funeral and burial expenses in the future. So the spend down rules and look back period are very important to understand for anybody who is getting older, closer to the age of 64, and who may want to, at one point apply for and start receiving Medicaid. The look back period here in California is only 30 months, so 2.5 years. It's half of what most other states in the United States are. In most other states, it's 60 months, so 5 years. And this look back period basically just means that from the date that the person applies to start receiving Medicaid, the Medicaid office, the Department of Healthcare Services, is going to look back 2.5 years to see if you've transferred away any of your money that violates the spend down rules. Now, spend down rules what the spend down is, it's simply just a financial strategy to lower a person's income and assets so that they can qualify for Medicaid. Now, this is not a do-it-yourself project. I have had, we're in a couple of cases where we're litigating where children of an elderly person tried to spend down their assets, but then, violated the spend down rules. It's actually a form of elder abuse. So you want to make sure that you're working with a competent attorney, probably a financial advisor and a CPA as well, or other tax professional, to make sure that you have a full, complete strategy that's going to work in the future and not, render the applicant unable or unqualified to receive Medicaid. During the look back period, within the 2.5 years before somebody applies to start receiving Medicaid, they can spend their money and it's properly to be spent down by spending on legitimate debts, such as medical expenses, equipment like eyeglasses, hearing and mobility aids, prepaid funeral expenses, if you're going to be paying a caregiver, all of those, if you prepay your mortgage and your insurance, all of those are acceptable ways to spend down somebody's assets so that they can eventually apply for and qualify to receive Medicaid. Gifts are not. So if grandma is getting older and we want to make sure that grandma is going to be approved to start receiving Medicaid here in the near future, you cannot have grandma start gifting away money to kids or grandkids, because it's going to violate the spend down provisions. When grandma goes to apply to the Department of Healthcare Services to start receiving the Medicaid, they're going to ask for tax returns, bank statements, and they will ask for details about the gifts. So you want to make sure you're not doing it on your own and that you have competent legal counsel to help you. So I have a couple examples for the burial and funeral trust, and then I will pause for questions. Again, for anyone who joined late, the chat box is open. So if you do have any questions for me, then please leave it there. Otherwise, you can contact me afterwards as well. So example number 1, a single person who is 65 years old owns one home, one car, and has $17,000 in assets, mostly just cash in the bank. They're receiving $15,000 of annual income. At this point in time, this person's not going to qualify for Medicaid. So if they go and fill out the application, submitted it to the department, they're going to get a straight denial because they have too much in assets. They actually have their income of $15,000 is still below the limit for one person, so that aspect will not disqualify them. But having too much money in the bank is not gonna allow them to be qualified to receive Medicaid. So if this person transferred $15,000 to the funeral expense trust for funeral and burial expenses that they or their family members would have to pay in the future anyway, they would then only have $2,000 remaining in countable assets and would therefore be eligible for Medicaid. So this person does not need to, say they created the funeral expense trust on a Monday, they could actually apply for Medicaid on a Wednesday and likely get approved, because this creating a funeral expense trust is not violating the spend down rules during that look back period. So example number 2, this is kind of the opposite side of the coin. This same person who is 65 years old, again, owns one home, say it's a $2 million home, one car, let's make it a $100,000 car, and they only have $17,000 in cash in the bank. They have $15,000 of annual income, and they decide to give $15,000 to their child 1 year before applying for Medicaid. So 1 year, 12 months before applying, that is during the look back period. So, you know, the department's going to look at their tax returns and bank statements and see this transfer and ask for additional details. Unfortunately, this person's application will be denied because this gift violates the spend down rules within that 30-month look back period. If we change the scenario a bit and said that this gift happened 3 years before applying for Medicaid, then there is a chance, probably a very good chance, that this person's application would not be denied, instead be approved, because that would be outside of the 2.5-year look back period. And in this example, if their application gets denied, the result is that that person, that elderly person, or their family members are going to be forced to pay for their medical expenses out of pocket. So, you know, not a great result for this family. Do we have any questions about funeral expense trusts at this time? Doesn't look like there are any questions in the chat box, so I will continue going on to the next type of irrevocable trust that we'll cover today. So the second type of trust that I wanted to cover is a very popular trust. I would say the funeral expense trust is not as popular as the special needs trust, but the special needs trust is very, very beneficial for a lot of people. The purpose of the special needs trust is that it allows physically or mentally disabled or even chronically ill people to receive income without reducing their eligibility for public assistance benefits, such as Social Security income, supplemental Social Security disability income, Medicaid, etc. So the special needs trust is a vehicle for a parent or a guardian to leave an inheritance to a developmentally disabled child. So we have a couple clients with, you know, children who are developmentally disabled. They want to make sure that they're going to receive a portion of their estate if anything were to happen to them, if they were to pass away. So we have what's called a testamentary special needs trust, which will basically allow their share of the estate or their inheritance to be funded into a special needs trust that would be created upon that parent's or guardian's passing. The special needs trust is also, we work with personal injury attorneys and law firms quite often for car accident victims, people who suffer from a traumatic brain injury or may be in a coma, even temporarily. We want to make sure that we form a special needs trust, typically through the court, in order to receive personal injury settlement funds. A lot of time, these victims who have been in a coma or have a traumatic brain injury, they no longer have capacity to sign the legal documents for themselves. So if they don't have a trust or a power of attorney or an advanced healthcare directive in place before they're injured, then they will need to form the special needs trust through the court, which we can help with. So the special needs trust funds, there's very specific do's and don'ts that you can use the funds for. And that's what allows the Department of Healthcare Services to not disqualify the person. As long as these funds are only used to provide additional financial support for things that are not traditionally paid for by the public assistance benefits, then the trust funds will not have to be paid back later after the beneficiary's passing. So the trust funds cannot be used for certain food or shelter expenditures because that's what the government assistance benefits are for. And most importantly, the special needs trust funds cannot ever be distributed directly to the beneficiary. Again, that goes back into those Medicaid qualifications and Social Security income qualifications. There has to be a financial hardship. So they cannot have, a single person can never have more than $2,000 of cash into their bank account at any time. Special needs trust funds, the primary purpose of them is to maintain the beneficiary's quality of life. So, a lot of people with disabilities are still high functioning and they still want to maybe take a guitar lesson or art lesson. That's what the special needs trust funds are for. They can be used to pay medical and dental expenses, payments of caretakers, transportation costs. They've actually, they can be used to purchase a vehicle or a specially equipped van, or wheelchairs, electronic equipment, insurance, and legal and guardian expenses. So the trust funds can be used for a very wide variety of things, just not certain food or shelter expenses, and never distributed directly to the beneficiary. So these are the types of people who might need some examples of who may need a special needs trust or who would benefit from one. Parents and guardians with a physically or mentally disabled or chronically ill child. They definitely want to make sure that upon their passing that their child's share of their estate is not distributed directly to them. We have had situations where we have to go in and modify a trust through the court after a parent passes away to transfer or to modify their trust share into a special needs trust so that they can not be disqualified for their government assistance benefits. Parents and guardians with a child or ward who has alcohol or other substance abuse issues. These types of issues qualify as chronically ill. So we can make sure that these types of people are not going to lose their government assistance benefits, and that their trust share is not going to be at risk of creditors attaching liens and judgments. An adult child with an elderly parent who needs long-term planning in order to qualify for Medicaid in the future. So this goes back to the burial expense trust or the funeral expense trusts. We want to make sure that mom and dad are always thinking ahead, many years, probably I would say at least 4 to 5 years before they turn 64. So as soon as people start turning 60 years old, they need to start thinking long-term for insurance wise. And lastly, people who have been injured in an accident and expect to receive a personal injury insurance settlement. I kind of went into that a little bit earlier. People who are in a coma or do not have the ability to make decisions as to whether to accept in a settlement cannot make that decision for themselves. So they will need a special needs trustee to be able to settle that case for them and then receive the funds in the future. So a few examples for the special needs trust. Example 1 is a parent with a high functioning developmentally disabled child who is receiving government assistance benefits. This parent wants to make sure that if he or she were to become incapacitated or pass away, that child's inheritance would be transferred into a special needs trust rather than to the child outright. You want to make sure you do this on the front end rather than the back end, because as you're putting together your estate plan, it would be, basically just one more article to add to the trust. Now, if you don't do it on the front end and you were to pass away and, if the child was at risk of receiving an inheritance that would disqualify them from receiving government assistance benefits, then we would have to go into court and ask the court to modify that trust into a special needs trust. Example 2 is the car accident example. Somebody suffering from brain injuries or is in a coma. This person's family will need to form a special needs trust for the injured person, possibly through the court. And that special needs trust is the vehicle that's going to receive the personal injury insurance settlement funds. And again, because the special needs trust gets its own taxpayer identification number, that is what allows it to be its own legal entity for the purpose of receiving those funds. Are there any questions about special needs trusts? I don't see any questions yet. So with that, I will conclude. Please contact us. That's our phone number and our general email. We are always here to help for you and your referrals. Thank you. I'll turn it back to Jody.
Thank you very much for joining us this afternoon for the first in our webinar series of empowering communities during COVID-19. Next week, we will have another webinar in the series. I will follow up by email to each of you with a link of this recording in case you might want to refer to it later or pass along to somebody else, and also with information for next week's webinar. Thank you so much for attending. Have a great afternoon.